Hello and welcome to episode 97 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away today. In today's episode, I'm going to talk about a new case that we're taking on. You all heard me complain about the Nova Scotia forest lockdown last week. And this week, I'm happy to announce that we will be challenging that.
Yay! Plus, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to update you on the Ontario Court of Appeal's decision that upheld a lower court decision that found that first past the post voting systems are not discriminatory against women and minorities and do not violate the right to vote under the Charter. Surprise, surprise. And this decision also has some really interesting commentary on some other stuff, including the meaning of equality and how seriously we should be taking social science experts. So this decision is Fair Voting BC versus Canada. And I think the CCF might have been the only organization present as an intervener to defend the constitutionality of the voting system that we've all had in place since Confederation, from claims that it is racist and sexist. So thank you to our donors and to our counsel, Asher Honigman, for defending what I think is basic sanity. The real headline here, I think, is just that this is a very good decision. It's pretty much what we hoped for. It was written by a judge named Grant Huscroft, joined by two colleagues on all but a couple small points where one judge disagreed. So Justice Huscroft made very clear in this decision that this really wasn't the type of case that should be in front of judges in the first place. If you want to challenge the voting system, that's obviously a question for policymakers. That's why we've had referendums on doing that in the past that have failed here in Ontario. It's not for judges to decide. And Justice Huscroft makes two other points that I think are really important. First, he explains that social science experts aren't entitled to decide what's good or bad policy. And judges should be reticent to make assumptions about things like the breakdown of the sexes or different racial groups in the House of Commons being sexist or racist, which is what the judge at first instance did. So, to recap the case, for those who aren't familiar, the appellants here have been arguing that the first past the post system, that is the system where we elect 343 members of the House of Commons based on whoever finishes first in each riding, even if it's just a horse's nose before the second place candidate, violates Section 3 of the Charter, the right to vote, and Section 15 of the Charter, the right to equality before and under the law. And both arguments were always a stretch. Section 3 just says every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. It doesn't say you have a right to a particular voting system that you think is better than the one we've always had in place. And that's what the judge found. Among their arguments, I won't get too deeply into them, but they said first past the post results in wasted votes because people whose candidate doesn't win in their riding are not represented in Parliament, and that other systems like proportional representation, where members are appointed by parties from party lists in proportion to the share of the votes they get nationally, somehow does a better job of preventing wasted votes, which of course ignores the fact that people whose candidates lose do still get an MP. It's just not the one that they actually voted for. They also said that first past the post diminishes the value of votes when people vote for small parties. So the Greens somehow have a constitutional right to more ridings than they get. I don't know why that would be. And finally, they said first past the post violates the principle of majority rule, i.e. that elected representatives should represent a majority. But how is that even a constitutional principle in Canada when we've had a system of whoever gets first place is the one who gets the seat? Like, it just doesn't make sense with our constitutional history. On equality, their argument was that all they needed to establish to show that the Charter right to equality was violated was that first past the post contributes to underrepresentation of women and minorities in Parliament. and that it does so by incentivizing political parties to predominantly run white men as candidates. And I don't know if this is even necessarily statistically true anymore. I know there are some ridings where all the candidates have been South Asian, which is perfectly fine. So I just think that's a bad argument. They also said that the application judge who first looked at this wrongly denied that there's no nexus between the electoral system and the representation of women or those of racialized groups in parliament. And they did this because they pointed to some expert evidence from New Zealand. So the CCF was there to argue that the voting system is constitutional, that nothing in the charter requires the voting system, a voting system different from what we currently have. And this argument was generally taken up by the judge, who found that judges aren't permitted to interfere in the design of the electoral system, let alone require it. So anyway, putting that aside, the finding was what we want. One of the really interesting things that happened here is that Justice Huscroft used this as an opportunity to remind lower court judges that they need to be more wary of what the experts are telling them, especially the social scientists, who are usually talking about very contested things and are often motivated by their own policy preferences. So he writes, social science research is concerned with human behavior and typically has significant normative dimensions. Often what appears to be disinterested conceptual or empirical analysis is better understood as marshaling of facts and arguments to create a case for the policy change favored by the author. Evidence that is the product of such research must be assessed with an awareness of the researcher's objectives and in the knowledge that there is considerable disagreement, reasonable disagreement amongst social science experts on everything from causation to policy preferences. All of this is to say that policy recommendations of those within the academic community must be evaluated by the soundness of their observations and arguments, not by their credentials. Academic views are not entitled a priori to priority over anyone else's. And he adds, it's difficult to accept that a conclusion that the federal electoral system is discriminatory should depend on the social science findings of a single judge. The nature of the problem is put into sharp relief by the application judge when he said, since the evidence does not establish that implementing proportional representation in Canadian elections would do any better than first past the post, the Section 15 claim is not made out. Justice Huscroft says, I don't see why the constitutionality of the federal electoral system should depend on this type of argument, and how could evidence establish that a foreign electoral system will deliver better results? At the end of the day, this is academic conjecture about how a different electoral system would operate in Canada. It's usefully discussed in academic development settings, but it's hardly the stuff of constitutional law. Okay, so love that. The second really interesting point is what Justice Huscroft says about the test for equality. So Justice Huscroft confirms what seems very obvious to me, but that was put into question by the Supreme Court case Fraser, which is that this was the decision, by the way, that allowed Ontario's teachers to argue that math tests are unconstitutionally racist because statistics show that some races do better on them than others. Huscroft says, correctly in my mind, that Section 15 can only be violated where the government has caused the distinction between various groups, i.e., it caused the different outcomes for women versus men or one racial group versus another, including in the House of Commons. And he writes, if mere statistical disparity in the application of a law were sufficient, the scope of adverse impact discrimination would be so broad as to trivialize the concept. And obviously this has to be right, because you can always find some statistical difference in outcome between groups. You know, for example, think of nurses hired by the government. They're usually going to be more female. Think about firefighters. They're usually going to be more male, and there should be no discrimination based on gender. But just because there are more of one group than the other doesn't mean there's discrimination. It's probably just differences in, preferences between sexes about what types of jobs they do. Justice Huscroft adds, and I'm going to read a pretty long passage here because I just think it's so good. He says that putting the appellant's case at its highest, there is evidence that some scholars think that proportional representation will yield better outcomes, but their opinions provide no support for the conclusion that first past the post creates or contributes to a disproportionate impact. Thus, I agree with the application judge that the appellant's Section 15 argument, that's equality, must fail. That being said, I part company with him where his analysis strays into political and policy realms. For example, the application judge notes the expert's view that attitudes towards women in the political arena are sociologically and culturally determined, and finds that there is no evidence that any political parties are or would be better for women than any other. This suggests a normative judgment about of some sort, but is that for the judge to make? Better for women on what criteria? And how is the question whether any political party would be better for women relevant to the constitutionality of the electoral system? The application judge asserts that the percentage of women in parliament is still too low and adds that Canadian political leaders and Canadian society overall should be encouraged to strive for gender parity. With respect, these sorts of remarks are out of place in a judicial decision concerned with determining a constitutional challenge. So too is the application judge's apparent endorsement of expert evidence that Canadian society is systemically sexist and racist. The concepts of over and underrepresentation are discussed as though they're neutral observations devoid of normative content, but normative judgments are implicit in both observations. Overrepresentation means that too many men are in parliament is a bad thing. Underrepresentation means that too few women and racial minorities is also a bad thing. Both judgments suggest that the composition of parliament may be more or less legitimate depending on its demographic diversity. They also appear to suggest that a more diverse parliament would be a better lawmaker. These are highly contestable political judgments, not matters of constitutional rights governed by the Charter. So I think those are two really important things to say about, social science evidence and not having the social scientists and experts making the policy, and also that judges shouldn't just make assumptions that, one system that seems to, on expert evidence in New Zealand, suggest more women might be elected is necessarily better, because that's a normative judgment for people to decide through elections. So Christine, I don't know if it's the same for you, but when I was reading this, I couldn't help but think about our discussion about bike lanes from last week and the apparent right to bike lanes in Toronto. What do you think? Did this decision make you think about that
It did, yeah.
as
And it
well?
also made me think of Kenyinda, which is a case that was recently heard at the Supreme Court that we intervened in. That was also a case about competing social science evidence. And in both cases, kind of the problem of the government was they didn't marshal enough academic social scientists from universities to come and make their point, because I don't think they should have to. The job of a judge is to apply the law, not to, weigh these different policy considerations and come up with what the ideal society should look like based on what some academic thinks. So I just love these lines in this decision from Justice Huscroft. I also love the lines about Section 15 that he has in there about how Section 15 should be properly interpreted and applied. Section 15, I think the jurisprudence around Section 15, the equality rights part of the Charter, is such a mess. It's just all over the place. Kenyinda is supposed to add some clarity when that decision comes out. We will see. We had argued for kind of not a reformulation of the test, but a clearer application, a clarification of the test. So, I mean, I was so happy that we got to get involved in this case. I wonder what the discussions internally among the judges are at the Court of Appeal about these issues, because they seem to be reaching different conclusions. I just don't think it should be the case that the government has to marshal some, dip one academic on one side of an issue to counter some academic on the other side of the issue, when it just is. These are just policy choices. The court should just lay down the law, say this is a decision for democracy, not for the courts, and kick these activist litigants out. Um, if you want a different policy outcome, elect a different government. Don't ask judges to fill that role. So let's turn now to my news headline. It seems like the only thing that anyone wants to talk about right now is the Nova Scotia forest lockdown. Obviously, that also includes Josh and I because we've been talking about it a lot. We are going to be litigating this case. I'm so excited about it
Breaking
because
news.
yeah, Josh and I were doing so many interviews over the weekend. I think I lost track of the number that I did. Um, Josh, do you know how many you did? It was a lot.
10 or 11 so far. Yeah.
Yeah, it was on every network, like Global, CBC, CTV. Um, I don't know what it is that has captured the public attention about this issue because it's captured mine too. I mean, maybe it's a slow news cycle, but my sort of theory is that this is a rehash of some of the same things that people said during COVID to keep us all locked up in our houses. And a lot of people have these resentments that are still active under the surface. And they just are like so angry that this is happening again with a new justification, and they're ready to fight this whole thing all over again. Um, so it has been dominating the news cycle, and I have become increasingly more angry about it the more time I've spent talking about it and thinking about it. Um, so we were scrambling over the weekend, Josh and I, trying to figure out what we should do. And so I'm announcing today we are going to be doing a judicial review. We have retained, or we're about to sign a retainer with a really amazing lawyer from Nova Scotia to represent us in a judicial review. So, just to update everybody on kind of what's going on and what our approach is going to be, there was that proclamation by the Minister of Natural Resource prohibiting entering any area of the woods for the purpose of traveling, camping, fishing, or picnicking, or any other purpose without a valid permit. By the way, the permitting process seems to be fake. Like there doesn't actually seem to be a process in place to obtain one because we've been talking to individuals who have tried to get one, and the Ministry of Natural Resources has told them, I'm too busy to deal with this. This isn't important enough. So, okay. Um, so keep in mind that woods is defined really broadly in the Forests Act in Nova Scotia. It includes forested land and rock barren, brush land, dry marsh, bog, or muskeg. It applies to crown lands as well as private property. And while private property owners can use their own woods, they can go into their own forest. They can't invite other people onto their property to go into the woods. And then there's a $25,000 penalty. Media has reported that at least 6 people have already been fined for a total of $150,000. I bet that there are more now. That was from over the weekend. Um, the proclamation states that you can get these permits, and they did give one out that we know of to a Micmac group that hosts a theater performance in Halifax in the forest. I actually think that they should be allowed to do that. But I don't know what process they went through to get this permit, but they apparently were given one. Meanwhile, other people don't know how to obtain them or they've been denied. So we are planning to seek this judicial review of the proclamation as a public interest litigant. We will be arguing that the proclamation exceeds the authority of the statute because it applies province-wide to all woods when the act itself actually only contemplates travel bans in zones of the woods, sort of more similar to what they do in British Columbia. That's what the legislation actually contemplates, but then the proclamation applies everywhere without any sort of drawing or clarity about where it actually applies. And we also will be arguing that the minister did not proportionately consider the impact of this proclamation on charter values, including freedom of assembly. And we would probably also be arguing that it violates Section 7 of the Charter, the right to life, liberty, and security of person, because the statute does provide that a violation under the act can result in a term of imprisonment, and therefore your liberty interest would be engaged. We would argue that it violates the principles of fundamental justice because it is vague and overbroad, because it's really impossible to know what actually counts as the woods. A problem that is pretty well illustrated by the fact that some parks and trails are open randomly while others are closed. And the premier has made all kinds of statements about how it applies to some things and not others that actually would be captured by the proclamation, including, I think, traveling for fishing. So we have interviewed a number of people who are impacted by the forest lockdown, including a really lovely woman who runs eco tours in the forests. She also hosts clients on her property to sit in her forested lot at her own property and have tea and talk about their health. And she runs educational workshops on this property to teach about foraging and healthy living. And she actually requested a permit to keep doing this, but she was denied while that other group I described was allowed to proceed totally arbitrarily. So this case, it's a classic debate between liberty and security, which is really good timing, actually, because we have a new report that we are also releasing today. It is all about safetyism, this notion that safety is the highest value. So the report is on our website, theccf.ca/safetyism, and it's called Safety Above All, How the Culture of Safetyism is Eroding Civil Liberties in Canada. And in that report, I discuss how some of the most grotesque violations of civil liberties in our history, from the internment of Japanese Canadians to the abuse of the War Measures Act in 1970, these were all justified in the name of keeping us safe. And the report examines why we need to resist that type of thinking. So you can go and download that at theccf.ca/safetyism. It's really interesting timing that it's coming out at the same time because it's something I've been thinking about for a long time. Josh, what part of this forest lockdown makes you the most angry, and why do you think it is the number one topic in the news right now?
Yeah, so it's the number one topic in the news, like you say, because during COVID, we were told, we're going to have 2 weeks to flatten the curve, and then it became 2 years of increasingly arbitrary, nonsensical limitations on our rights and freedoms, which some people were, fine with, whatever govern me hard or daddy legislation they can come up with, but these things had real impacts on individual people. And probably the thing that's made me most angry so far are Scott Reed's comments. And Scott Reed is a liberal strategist who is normally quite reasonable, in my opinion. But in this particular case, he went on a podcast, The Curse of Politics, where he said that essentially the people opposing this are, selfish, that they're MAGA, and that they're, sitting in their driveways in Toronto drinking beer, that they're not, people who hike, where they're just like fat MAGA types who sit in Toronto driveways drinking beer. I don't have a driveway. I wish I did. Anyway, so, and the funny thing is, Scott Reed is probably most famous for helping Prime Minister Paul Martin lose an election because he said
Beer
that,
and popcorn.
yeah, that conservatives giving $100 a month to parents for children would just spend it on beer and popcorn. So I don't know. Anyway, you'd think you would have learned that lesson. So that's the thing that made me the most angry because this is affecting a lot of people in various ways. We understand the fire risk. We understand it's reasonable to put in place things like burn bans because those actually cause fires. But we don't agree with arbitrary restrictions on simply, walking on trails, which is how a lot of municipalities are interpreting this, saying that this entire park is closed. You can't go on any trail. You can't go on this road. You can't go to private property and sit in the forest and drink coffee with your friends. And it's affecting real people. We're hearing from them, right? Like we heard from the woman you described, whose business is now affected for no good reason. We've heard from a mother who cycles her kids to day camp through a trail who would now have to go on the highway if she wanted to, cycle with her kids. Like we're hearing from all kinds of people impacted by this, and mental health is one thing. Like most people that I know who have mental health concerns, they use exercise to deal with that. And now you can't, go and run on a trail. I could go on and on. I won't. I'll leave it there and just say people who want to follow along should go to our website and sign the petition at TheCCF.ca to tell the premier to rescind this and to.
Yeah, over 4,000 people have already signed it. And part of what is pressuring us to litigate this is not just how angry we are, but the thousands of people who are telling us we need to litigate this. So I'm really excited.
Yeah, me too. It's a big, big deal. So let's take our break. And when we come back, I'll give you my bad legal take, which is also about Nova Scotia. And then Christine can give you hers, which I believe is also about this too, because there are just so many. Okay, so my bad legal take goes to the province of Nova Scotia, and there were a lot to choose from, like I said. We could have gone with, New Brunswick Premier Susan Holt, who said that they're also banning people from going on crown lands because someone might need to be rescued, and there are not enough people to rescue them because some of them are fighting forest fires. But instead, I'm going to go with this one that Nova Scotia just tweeted out today. So the province of Nova Scotia said on Twitter, fishing is allowed as long as it's not in the woods, or you have to travel a significant distance to get to it. And the reason that Nova Scotia has said this is because the premier said that when he announced these restrictions. He said, well, if there's a short trail to a fishing spot, that's fine. You can do that. But that's not true. The law, the order says there's no travel to the woods. So, woods includes lakes, it includes rock barren land. It's not necessarily all that clear what that means, but on my read of the order, there's a very high likelihood you would get a ticket for $25,000 if you go fishing and you take a short trail to get that, which just goes directly to why this is vague and why it's arbitrary. And so, yeah, that's my bad legal take of the week. You don't make law by a press conference, you make it by written orders or very occasionally, orders that are verbal, but the premier cannot make law by press conference. And no, Nova Scotia fishing is not allowed if you just take a short trail to get there. Christine, what's your bad legal take?
Yeah, I mean, that's a huge rule of law issue as well. I mean, people, that's not how you
It's
make orders,
bad.
and people don't know what the law is right now in Nova Scotia. It's so bad. Yeah, I'm just so obsessed with this forest lockdown. I'm really mad about it. And uh, I want to give my bad legal take to some of the people who are justifying this in a really, really crazy way. So, a number of people have justified the ban on walking because they say people walking in the woods might be drinking water and they might drop their water bottle in the woods. And under some theory they have, a water bottle in the woods can have light go through it and refract and magnify and act as a lens to concentrate the sun's beams and spark a fire. And some smart people have argued this. I think you were in a debate on the Hub, Josh, and Steve Mahar actually made this claim. I would have lost my mind. I've also seen people make it on Twitter. For example, someone on Twitter named Agitated User, which is an appropriate handle, I guess. They claimed that walking in the woods is dangerous because people drop glass bottles, cellophane wrappers, and mylar bags. And under this remote theoretical scenario, the sunlight through these objects could spark a fire. I mean, this is the level of scientific discourse that resulted in those extended COVID lockdowns. By this standard, we could justify banning anything. Like I want someone to show me a single incident of that ever happening in the forest. Like I do not believe that this has ever happened. I understand that there have been a few documented cases where someone put a water bottle in their vehicle and a full water bottle caused like a small burn hole in their seat leather um, when the car was parked in full sunlight in a hot environment. I just do not think that you could have that fact scenario ever realistically occur in the woods and actually cause a fire. This is a justification to ban anything. I mean, if you are so concerned with that, which is like a one in a trillion scenario, it seems like you could ban driving, swimming, just stepping outside. All of those things are much more dangerous and likely to cause harm than this water bottle in the forest scenario. And I think that the people arguing this just do not seem to have any risk tolerance or ability to gauge actual danger. I mean, if Steve Mahar thinks that water bottles are this dangerous, we should probably ban water bottles altogether. And I want to know if he has ever ridden a bike, if he's ever driven in a car, or if he lives in his closet cowering because there is some remote possibility that an asteroid could strike the Earth. Like, these people do not know how to assess risk, and they are trying to impose these restrictions on us on the basis of their completely irrational, paranoid, worst case scenario, fortune telling, crazy mentality. So, no, water bottles in the woods are not likely to cause a forest fire, so people should be allowed to walk in the woods.
I just have to say before I close out the show on Mr. Marr in particular, he said that, he had to move his run from a nice forested trail onto the highway to comply with this order, and he's perfectly fine with doing that. And I just want to point out there are, hundreds of people hit by cars every year on the roads of Nova Scotia, and first responders have to respond to that. So they should probably ban that too, so that first responders can just,
He is so much
deal with the
safer in the
fires.
woods. He's so much safer running in the woods versus running on the highway.
Yeah.
Oh my gosh.
Anyway, we could go on all day, but we probably shouldn't. We'll just focus on the case. So, as usual, we hope you'll rate us, review us, and subscribe if you haven't already. You can support our work by subscribing to the CCF's YouTube channel, by following us on X, by signing our petitions, like our petition telling Tim Houston, the Premier of Nova Scotia, to rescind this ban and put in place more reasonable restrictions. And the CCF is a nonpartisan legal charity funded by your donations, so please do click that donate button on our website if you can. Thanks for listening.